Welcome back to Law Minds YouTube channel, where we dwell into the complexities of the legal world. Today, we are going to explore an essential aspect of Code of Civil Procedure 1908, first appeals. If you've ever wondered what happens after a civil case verdict, this video is for you. I'm Shashanki, and without further ado, let's get started. Before we dive into the details, let us understand what first appeals are. In the Indian legal system, the Code of Civil Procedure 1908 provides for two stages of appeals, the first and the second appeal. Today, we'll be mainly focusing on the first appeal. First appeals hold a significant place in our legal framework, allowing parties dissatisfied with the lower court decision to seek redressal in the higher court. Section 96 to 99 of Code of Civil Procedure 1908 outlines the process and grounds for filing a first appeal. Now, as we have mentioned that there are two types of appeal one can go for, but where exactly has been appeal defined? Appeal has been defined in Black's Law Dictionary as the complainant to a superior court for an injustice done or error committed by an inferior one, whose judgment or decision the court above is called upon to correct or reverse. It is the removal of a cause from a court of inferior jurisdiction to one of superior jurisdiction for the purpose of obtaining a review and retrial. Section 96 to 99 talk about first appeal, whereas Section 100 talks about second appeal. There are different subcategories under which appeal has been divided. An appeal can be filed against the original decree. Now, if you do not understand the meaning of original decree, order, and judgment, you can refer to other videos. Appeal can also be filed against an order. Appeal can also be filed from an appellate decree second appeal to higher court, and appeal can also be filed to Supreme Court. Further, let us look into the essentials of appealing cases. An appeal is a proceeding where a higher forum reconsiders the decision of the lower forum. Now, basically, this happens when there is either some question of law, question of fact in reference to jurisdiction. It can confirm the same order, decree, or judgment, or it can reverse it. It could modify the same decision. Therefore, there are three different essentials of the appealing cases. A decree passed by a judicial administrative authority. Now, the essential element, the first one being that appeal can be filed against the order or a decree that has been passed by an administrative or judicial authority. Here basically courts have been mentioned, and when we talk about administrative authority, we talk about tribunals. If you haven't heard about tribunals, there can be different types of tribunals, such as army tribunals are there, AFTs are there are DRTs, debt recovery tribunals. So all those tribunals also come under appeals. Secondly, an aggrieved person, not necessarily a party to the original proceeding. Now, an appeal can also be filed by a person who is not a party to a case, but he has been aggrieved by that decision. For example, there are two people fighting in reference to a property. Now, there is a third person who actually owns the property. If the court has decided in favor of one of the parties, but the aggrieved person, that is the real owner, is aggrieved by it, he can file an appeal in reference to that decision that they have received. Even though he wasn't the party to an original proceeding, he can still go to the court appealing in that order. Why? Because he was aggrieved by that particular decision. A reviewing body instituted for the purpose of entertaining such appeals. Now, where exactly would these appeals be filed? Obviously, when we're talking about appeals, they are filed from an inferior jurisdiction court to an higher jurisdiction court. So there should be a reviewing body instituted that should actually look into this appeal. Next, we have right to appeal. The right to appeal is a statutory and a substantive one. The statutory nature of an appeal implies that it has to be specifically conferred by a statute along with the operative appellate machinery, as opposed to the right to institute a suit, which is an inherent right. It is substantive in the sense that it has to be taken prospectively unless provided otherwise by an statute. This right could be waived off via an agreement, and if the party accepts benefits under a decree, it can be estopped from challenging its legality. However, an appeal occurs to the law as found on the date of the institution of the original suit. Now, one right to appeal. Under Section 96 of CPC, it has been provided that an aggrieved party to a decree which was been passed by a court while exercising its original jurisdiction is conferred with at least one right to appeal to a higher authority designated for the purpose unless the provisions of a statute make an exception for it. Section 97, 98, and 102 of CPC enumerate certain conditions under which no further appeal is permitted, hence attributing to a single right to appeal. Then there is a mention of no right to appeal. No person has a right to appeal against a decision unless he is a party to the suit except on special leave of the court. An essential element to be taken into account while considering one's right to appeal is whether such person is adversely affected by the decision, which is the question of fact to be determined in each case. Further, we'll be looking into the grounds of filing first appeal. When can you file a first appeal? When a filing of the first appeal, it is crucial to establish the valid grounds for challenging the trial court's decision. These grounds could either include error in fact or law, improper admissibility of evidence, misinterpretation of evidence, or failure to consider relevant legal precedents. The appellate court will review these grounds to determine the merit of the appeal. Next, we have one of the landmark judgments, that is Lachmaneshwar Prasad Singh versus Keshwar Lal Chaudhary. One landmark judgment that sheds light on the ground for filing first appeal. In this case, the court emphasized that a first appeal is an opportunity for a fresh look at the entire case, not just a re-evaluation of evidences. This judgment established that the appeal court can review both the question of fact as well as law. Next ahead, we have interference with the findings of the fact. While the appellate court are generally cautious about interfering with the findings of the fact, they can do so if the lower court's findings are unreasonable, not based on the evidence, or against the weight of the evidence. There have been three particular cases or instances where the appealing court can actually interfere in the findings of the fact based on the lower court's decision. First one being when the lower court's decision is unreasonable or it defies logic and reasoning. Secondly, when the decision is not entirely based on the evidence. Now, when the complete absence of evidence supporting the judgment is not supported by either of the evidence that has been presented in the court itself or the proceedings itself. Third one being when it is against the weight of the evidence. That means that the evidence are pointing towards a particular fact and the decision is against that fact. Now, none of the evidence supports that particular judgment. Then the appellate court has the power or it has the option of interfering into the findings of the fact. Other than these three conditions, the court tries not to interfere in the findings of the fact that has been established by the lower court. Further, we have doctrine of substantial question of law. One of the most significant aspects of first appeal is doctrine of substantial question of law. This doctrine allows an appeal to be heard even if it involves only a substantial question of law without needing a question of fact. This doctrine ensures uniform interpretation and application of laws. Further, we have another landmark case, that is Sarla Verma versus DTC. Illustrating the doctrine of substantial question of law is the case Sarla Verma versus Delhi Transport Corporation. The Supreme Court ruled that a question of law that substantially affects the rights of the parties is sufficient to invoke the appellate court's decision or jurisdiction. Further, we have the discretionary powers of the appellate court. Appellate courts possess discretionary powers to allow or dismiss appeal. As it has been stated earlier that the right to appeal is not an inherent right, it is a statutory right. Therefore, the court has the power to either allow the appeal or to dismiss it and to not try it again. This discretion is exercised cautiously and judiciously to ensure justice is served. Courts may grant leave even if the substantial question of law is not raised if it is in the the interest of justice. So, as we all know, the basic foundation of law itself is based on the principles of natural justice, and the purpose behind appeals, courts, trials is to ensure that the ends of justice are served. Similarly, the discretionary power of the appellate courts is based, it might not be solely based on the question of law or question of fact, it can also try the appeal if it serves the interest of justice. And there you have it, an overview of the first appeal under the Code of Civil Procedure. It is a vital mechanism in our legal system that allows parties to seek justice beyond the trial court's jurisdiction. Remember, the process of appeals can be intricate, so it is crucial to consult with the experienced legal professionals for guidance. If you found this video informative, don't forget to hit the like button and to subscribe to our channel for further more legal insights. Let us know in the comments below that what are the topics that you'd like us to cover, and if you have any sort of doubt, you can ask the same by commenting in the comment section. If you want to read about various articles on legal topics, you can visit the website of Lawminds, and you can also read about various case briefs on the same. Hope you liked the video. Please like and share and subscribe.